Yep. Okay. Go!
Will you hand me my screen box?
Now go.
Court does call the case of Anderson versus Lyman. State your appearance, please.
Gloria Anderson. Armani Lyman.
All right, Miss Lyman, when the court says 9 o'clock, I mean 9 o'clock. We're waiting for you to appear at the courthouse.
Okay.
So that won't happen again, correct?
Yes, sir.
All right. This is the date and time set for trial. Is each side ready to go to trial?
Yes.
All right. Sanderson, you may proceed.
Should I stand there, sir, or right here?
You can stand wherever you want, that you'll be picked up on a microphone.
Okay. I want to give my opening statement. And then I have one.
Go ahead. Do your opening statement.
Okay. Your Honor.
Ma'am, put the microphone back where it was.
Sorry.
It will pick you up.
Sorry about that, sir. Your Honor, my name is Gloria Anderson, and I am the plaintiff and owner of the property at issue. I am here seeking a judgment for $14,606.46, which includes unpaid rent, court costs, unpaid water bill, and damages in the amount of $2,866. Ms. Armani Lyman provided false information on her rental application, including misrepresenting her residency, which influenced my decision to rent my home to her. This is not a typical landlord-tenant dispute. She has a documented history of property damage, unpaid rent, and disruptive behavior, as shown in the exhibits and witness testimony I will present. I want to acknowledge that I appreciate the court's efforts in landlord-tenant cases to maintain tenancy for individuals who might otherwise be homeless. However, this case is different because it involves actual property damage and destruction, not just homelessness. If the court allows Ms. Lyman to remain a tenant, I respectfully request safeguards to protect my home, because this is the only way I will have access to my property. The defendant will not allow me into my home and does not communicate with me outside of the court. While the lease allows me access with a 24-hour notice, Ms. Lyman has denied me entry, making court-order inspections necessary. Therefore, I request that the court order monthly inspections at a specific time each month so that these inspections are enforceable and I can return to court if Ms. Lyman fails to comply. Monthly property inspections with Mr. Ivory Clinton present to detect smoking inside the home. Inspection is scheduled once per month on a Saturday at a specific time set by the court, preferably 10 or 11 a.m. During inspections, I request permission to take photos of the property condition. I request access to inspect the entire home, including the basement and garage. I will bring an HVAC filter to the inspection and replace it monthly as part of regular maintenance. Inspections will confirm that there are no unauthorized occupants, no further property damage, and no smoking inside the home. I ask the court to instruct Ms. Lyman to allow access to the home for myself and a licensed contractor on October 2nd to repair a crack in the basement, scheduled to start between 8 and 10 a.m. and expected to last several hours. I am also respectfully requesting that the court return 2 zip drives in my possession. I did not present any video evidence in this trial, and these drives contain precious family memories. For this reason, I ask that these videos not be included as evidence. These methods are essential to prevent repetition of past destructive behavior, ensure compliance with lease terms and local laws, and allow me reasonable access to my property. I respectfully ask the court to grant judgment of $0.46 and if Ms. Lyman remains a tenant to consider implementing these court-ordered protective measures to safeguard my home. Thank you, Your Honor.
Ms. Lyman, opening statement.
Okay. So I have not been able to peacefully stay in the house. Every time I turn around, she's either down the street or have somebody watching me. So I would really like to be able to enjoy the home, which I haven't. I pay all this money to not be able to enjoy the home. I don't smoke, so there's no smoking happening on the property. There are no damages. And the judgment, that seems like a much, because she's including the rent that I had paid to you guys in escrow in the judgment. Also, I would like an addendum to the lease for my $750 that she said that she legally lied and said that she didn't know that she can put it as non-refundable because somebody else is suing her for the same $750. When I moved in May, I paid $3,300. It should have been prorated because I moved in on May 5th. So that should have been prorated $533 plus the extra $300 that's left over from the deposit. In June, I paid an extra $200. So I ended up paying $3,500. In July and August, I paid the $3,300. The only month I owe is this month. So from
This month being September or
yes,
October?
I can pay that tomorrow. So only every month is $3,300. So with the extra money, me paying the $200, prorated the $530, the extra $300 from the deposit comes up to $1,033. So I figured that I should take that from the rent, and it should be $2,267.
That you owe.
Yes.
So Anderson, you may call your first witness. Is that gonna be yourself or somebody else?
Okay, should I stand there to question the witness? Where does the witness stand there?
It's up to you. Where do you want to stand?
Clinton?
State and spell your first and last name for the record.
First name, right, that you are, you are in Q.
Your Honor, may I give this to Mr. Clinton to reference?
I don't know what it is.
It's evidence pack number 4 that I've already.
No, that's not the way it's done.
Oh.
You can question him and then
Okay. Mr. Clinton, how long have you known the the plaintiff, Miss Anderson? Yeah, can you hear, hon? How he has a hearing trouble.
get him equipment.
Thank you, Mr. Clinton. Mr. Clinton, how long have you known me, the plaintiff, Miss Anderson?
20 years.
Okay. In your experience, how have you known me to maintain my home, its cleanliness, its floors, the overall condition?
Almost perfect.
Almost perfect? Okay. Do you recall when I was preparing the home for sale in the spring of 2025? Okay. Do you recall the condition of the home when it was listed on the market in April 2025? Looking at the before and after photos in Exhibit 4, did you ever see a rear screen?
Exhibit 4 hasn't been admitted. I don't know.
I have, yes, sir. I gave them all to the clerk on.
It hasn't been admitted, ma'am.
The clerk, I came here on Friday and, Ann, or was it Ann? She said she would give it to you. She gave it, I put it in a packet
But
and
it hasn't been admitted.
how do I admit it?
Ma'am, I can't tell you that.
Okay, so,
I don't know who took the photos. I don't know when they were taken. I don't know any of that about these purported photos.
well, how can I get what I dropped off on Friday to you? So I thought you had them. I actually spent a lot of money to produce the color prints. It cost me over $20.
Really?
Ma'am, whether I have them or not doesn't mean that they've been admitted into trial. Who has to establish those photos and then attempt to try to have questioning regarding those photos.
Okay, I'll do that. Can I admit Exhibit 4 into court?
Ma'am, I don't know who, there's no testimony as to who took the photos,
The
what they
professional
are photos of,
of my house, the professional photos of my house, and then I took the photos of the damages.
and you need to testify about the photos.
Okay, so what, do you want me to say, go over Exhibit 4 with you?
I just want you to do the trial, but I'm not gonna just have you submit things, and I don't know if they've been presented to.
Yeah, no, I sent her all the files, all the files to the defendant.
I don't know what those files are.
The exhibits, can we, I spent a lot of money bringing the exhibits to court. And I dropped them off on Friday. She did a stamp, she put a stamp on them to give to you, and she said everything's fine, and so I thought you had the exhibits. I labeled them, I emailed them to you, but also printed them out, but I labeled them exhibits.
Maybe you're not understanding me. You can send to the court whatever you like. It doesn't make them an exhibit in the trial.
So how do I send them to be an exhibit to the trial?
I am not here to assist necessarily either side in this trial. Something the court to consider as evidence in the trial, you need to properly admit it.
So how do I properly admit the evidence, sir?
I'm not here as your lawyer, ma'am. I'm here as a judge.
Okay, so you want me to just ask him the questions then? I'll ask him the questions. Do you ever, Mr. Clinton, do you ever remember seeing the rear screen door ripped?
No.
Do you ever remember oil stains in the driveway?
No.
Do you ever remember me mounting a security camera on the south end of the home?
No.
Do you ever recall the master bedroom blinds being broken?
No.
And the front door lock, it was never an automatic door lock. It was also always a mechanical door lock, correct? Okay. Can you confirm for the court that the before photos accurately represent the condition of the property before Ms. Lyman took possession, May 5th, 2025?
Where did these photos come from?
They were photos I took when I was, after the home was prepared for sale.
Ma'am, you took the photos.
No, they were taken by a professional because they were actually put in the
Then
MLS.
how's he going to establish that?
No,
You need the
The-
professional here.
the professional photos were taken, they were put in the MLS, and then I took the damage photos.
What did I just say? Who took the photos?
The professional photos, two people,
Oh, goodness.
two people.
Objection, Your Honor. Lack of foundation calls for speculation.
What did he do to her?
Unintelligible. I don't understand the question.
Overruled.
He did not take the photos.
No,
You didn't take these photos.
I took the after photos. The before photos were professional photos for the home to be in the,
My question.
okay.
The photos that he just talked about, the witness did not take those photos.
No,
You did not take those photos.
no.
Then where's the testimony about who took the photos?
They were by a professional photographer who takes photos for listing a home in the real estate MLS.
Where are they?
He has a job. I can't afford to pay him to be here. And you don't allow Zoom testimony. So, I mean, I'm doing the best I can, sir. I don't have any money.
I'm going to tell you what. You did not make a request for that Zoom testimony.
I did.
And then
I
are you going to keep interrupting me? Because I'm not going to do this all day. The person that took the photos needs to testify as to those photos. Preliminarily.
I did not know that, sir. But if he could do Zoom,
Then that's not my issue. I'm telling you. Yes,
I requested Zoom for 4 other witnesses and I was denied because they live out of state.
because this individual did not consent. You should have at least asked her.
She doesn't talk to me outside of court.
You know what? I am not here to solve the world's problems. Only the issue that's in front of me. Did you make the request of her to have these?
She doesn't, I sent an
Did
email.
you make the request?
No,
Okay.
but she does not talk
That's
to
an
me.
answer to my question.
He can at least attest to the fact that the home was in good shape before she took it
I
over.
think he already told me.
Okay, that's fine. Mr. Clinton, can you please confirm that the MLS photos are the same photos that accurately represented the pristine and spotless condition of the property presented to Ms. Lyman? The home was in pristine condition when it was presented to Ms. Lyman.
Yeah.
Okay. Can you confirm that the broken screen door, oil stains, changed front door lock, security camera, broken master bedroom blinds, all occurred after Ms. Lyman took Tennessee?
Yes.
Clinton, how often were you at that property?
Before or now?
Before. Well, let's just ask this. How many times have you been to that property?
Or 110?
How many times before Miss Lyman moved in?
I mean, that's what's it?
Before Miss Lyman moved in.
Oh, about 50 or 60, not more.
And you've been out to the property since?
Yes, I have.
For what purpose?
Pick up the mail or,
For who?
for,
That's no good.
What's your relationship to Miss Anderson?
from the start, well, we've been friends for about 20-some years.
What is the relationship now?
We're still friends.
Just friends?
Just friends.
Go ahead.
Mr. Clinton, were you present in the district court on August 15th when Miss Gloria Vanderwell testified in front of Judge Washington regarding 5 Maplehurst Drive?
It's hearsay. Don't answer the question.
Did you see photos showing 2 bathtubs with running water left?
Where? Did he see photos where?
In Exhibit 6 that show the damage she did to Miss Lyman did to the Maplehurst property. They were
To whose property?
to her prior residence. He's seen the damage to her prior residence.
Were you there and saw the damage?
No, saw pictures.
I'm not going to allow it.
Even though it was in court that it was presented?
What did I just say?
Okay. Well, I'm learning, sir. Forgive me. Did you see the final water bill from Ypsilanti Township showing a final water bill for the Maplehurst property of $3,153.69 during Miss Lyman's tenancy at 5 Maplehurst?
Why am I talking about Maplehurst?
I thought it showed evidence of damage to prior property.
I don't. Have you ever been to Maplehurst, sir?
No.
You know the owners of Maplehurst?
No.
Do you know anything about that property? Other than that was a bad question. Do you have personal knowledge of anything regarding that Maplehurst property?
Okay, so,
I can't testify as to.
okay, I thought, because he was at the court, I thought he could do that, so. Okay, there's no further questions for Mr. Clinton.
Any cross-examination, Mr. Lyman? Any questions you have for him? No? Thank you, sir. You may step down.
And he's also Air Force, sir. I'm sorry, you're Army.
Other witnesses.
Miss Lyman?
Lyman, come on up.
Okay, this is gonna be questions about the lease to Miss Lyman. which I have a copy here if she needs it, but, rent, let's see here. Rent under your lease is due the 4th of each month, correct? Per line item number 41 of the lease.
It has 2 different dates on the lease.
Yeah, but the 4th it doesn't have the 5th, it has the 4th on line 41. I can show you. It doesn't have the 5th. It's due on the 4th. The lease provides only a 3-day grace period and imposes a $150 late fee on the 8th day, correct? It's line number 40, line number 4 on the lease. Isn't it true that you were late paying rent for July, August, and September?
I paid the rent to the court.
I know, but you were late on those days that you paid the rent. July, in fact, on the ledger, I can give the dates when you turned them in.
What?
On July, for July rent, you turned it in August 1st. For August rent, you turned that in September 2nd, and you still haven't turned September rent in. So wouldn't you agree that you've been late on paying rent all 3 months? Are you aware that partial rent payments are not accepted under this lease?
On the lease, she said I can deposit a check into.
Partial meaning like you couldn't just pay half of it one day and half of it the other. It all has to be paid at one time. Are you aware that if rent and late fees are not paid, I plan to issue a 7-day notice on the 5th day of the month and file with the court on the 12th going forward, and you will be expected to pay court costs. If I have to bring you to court to get rent, if I file a 7-day notice.
Was that a question?
No, I'm making her, no, I was making her aware of that.
You need to ask her a question.
Okay, are you aware that if rent and late fees are not paid, I plan to issue a 7-day notice on the 5th of the month and file it with the court on the 12th going forward, and you will be expected to pay the court cost.
What's the relevance?
That's just, it's a question just to make.
What's the relevance of that question?
That going forward, if she still remains my tenant, I plan to be on top of it as far as rent. If it's not paid, I will issue a 7-day notice.
What bearing does that have with anything the court has to decide today?
Okay, sorry. Strike that one. Under your lease, only you, the named tenant, are permitted to reside in the home without my written consent, correct? Isn't it true that your uncle and 3 children have been observed living at the property by several neighbors?
No, just because somebody seen people come over doesn't mean it.
Okay, line items number 19 and 9 and 19 on the lease. Did you change the locks on the home without my written consent?
I told you I was getting ADT.
Without my written consent? Did I write something down?
No, you know.
Okay. Are you aware the lease prohibits changing locks without the landlord's permission and expressly allows the landlord entry without notice in emergencies?
You knew I was getting security system.
Do you know that I'm able to go in emergencies? Fire, water?
Yes.
Okay. In an emergency such as water running continuously, fire, or a suspected medical emergency, do you expect me to break the locks to gain entry?
Oh, yeah.
Are you aware that my former tenant, Gabriella Anderson, died in Ypsilanti Township?
What's the relevance of that?
I have a history of a tenant dying in my property.
Why do I need to know that?
Because it shows why it's important to have access to a home. As a landlord, if somebody dies, I need to have access to the home.
Does she know that? And if she does, what's the relevance of that in whatever her answer is?
I'm making her aware that the reason why it's important.
This is not a proceeding for you to make her aware of things or what your expectations are.
Okay. I was explaining.
You don't have to answer the question.
Okay.
Go to
Okay.
your next one.
Okay.
Will you allow my licensed contractor, Affordable Dry Basements, to enter on October 2nd to repair the basement crack?
I don't know anything about a licensed contractor.
I sent an email to you at Armani Lyman.
You send a lot of emails, so I most likely didn't see it, but that's not a good day.
Well, I can,
You also mentioned that they could come in the spring, so.
yeah, but I don't want it to go through winter. I don't want it to go through winter. The crack is just getting worse, sir. I want to get it done before winter because
Are
they can't.
you going to ask a question?
I want to ask her when I can schedule Affordable Dry Basements to enter to do the repair in the basement. Are you aware that it won't pass certification with the crack in the basement? It won't. It's leaking now, sir. So we won't pass the certification.
Why are you talking? You were supposed to be asking questions.
Okay, when will you allow my licensed contractor to repair the crack in the basement? Okay, what month? So I can. Can I ask a question, sir? Of you? Because the crack is getting worse and it's damaging my property. It needs to be repaired.
That's a statement.
It needs to be repaired.
That's another statement. What's your question?
My question is, I need to, my lease states that I can go in and make repairs with a 24-hour notice. So she's going against my lease by not allowing me to go in.
Okay, once again, a statement. You asked, can I ask you a question?
So can I ask the court to enforce my lease? Can I ask the court to enforce my lease?
You can ask the court to do whatever you want. Whether they do it or not becomes a whole other issue.
Even though it's damaging my property. I'm just.
Next question.
Okay. Well, it was along with, that was, okay, I'll go to the next question. Okay. Under the lease, you're responsible for paying all utilities, including water, electric, correct? Okay. Have you paid the water bill for May 5th through August 31st, totaling $1,471.87?
I'm sorry, say that again.
The water bill is in my name. I have worked something else in my name.
Okay, because may I make a comment to the court? If the water bill, okay.
This is testimony.
Okay. Did you pay the DTE bill that was subject to shut off notice dated on September 17th? Yeah, as a landlord, they sent me a shut off notice.
Oh, for Pete's sakes. Why do I keep getting comments from you and not questions?
Okay, the question was, did you pay the DTE bill that was subject to shut off?
Answered it.
Did you paid it?
No.
Did you pay the electric bill? So the electric's off?
What does that have to do with you?
Okay. This is the next question. Do you plan to keep the home above 50 degrees this winter as required by the lease? Okay. Are you aware that you will be held liable for any frozen pipe damage beyond your security deposit resulting from temperatures below freezing or winter shutoff? Huh?
I am now.
Thank you. Line number 18 of the lease, repairs due to tenant's negligence. Are you aware that repairs due to your negligence are your responsibility? Will you arrange for the repairs of the torn screen, broken blinds, torn down insulation and oil stains in the driveway by a professional contractor?
I already told you last quarter that the following installation has been put up. The screen is on the checklist. The blinds will get fixed. And the oil stains are barely even visible.
But they're still there. So it will require.
Is that a question?
Well, So she's,
Or are you just gonna argue with her?
okay. My next question was, if you do not hire your own licensed contractor, will you permit my contractor to complete the repairs and reimburse me? Okay. Are you aware that these repairs must be completed before the next Pittsfield Township rental inspection, May 26th, to maintain certification? Thank you. Inspections and smoke damage. Are you aware that smoking is prohibited in the lease?
Yes.
Okay. Will you permit monthly inspections by the landlord with a witness present so landlord can document the condition of the home, including photographs and checking for smoke odor? Are you aware in the lease it says that I am allowed to do inspections with a 24-hour notice? So you don't want to go abide by the lease?
That's, she doesn't have to answer that.
Okay. Do you understand that if smoke odor is detected and smoke damage is documented, repainting and remediation of the entire home may be required at an estimated cost of approximately $10,000?
What, really? Where does that come from?
3,000 square feet will cost.
Where does that come from?
I'm just making her aware about smoke damage.
Why?
Okay, sorry, strike it.
Where
Strike it,
does
sir.
that come from?
I've been quoted $10,000 to paint that house.
By whom?
Contractor, because it's a large house and smoke will sink into the paint.
I don't know anybody named Contractor.
Nicholas Blake, licensed contractor.
Is he here to testify?
No.
Then I don't want any questions about any quote he's given.
Okay.
That's hearsay.
Okay. Sorry,
Next
sir.
question.
Yes, sir. Nuisance and children, line item 20. Are there 3 children residing at the property? Okay. Were those children left unsupervised in the street on or about May 22nd, prompting a CPS call? They were supervised? I don't know if you'll allow this question, but do you understand that the lease prohibits public nuisance and requires you to supervise children? Okay. Cameras and alterations, line number 20 on the lease. Did you install an exterior camera without written consent of the landlord?
Yes, but I did tell you I was being AT. And also the first court date, you said you had no problems with the cameras. So what's the problem?
I didn't authorize installation. I never said I didn't. No. I just said.
Yes, you did.
The prior court date, I said as a compromise, I would accept it, but I'm just going over what she violated. I thought we wanted.
So she installed cameras and installed the security system.
That's all I wanted,
All
just
right.
get confirmation. Are you, okay, can I ask this question?
I don't know.
I know I'm upsetting you. I'm sorry,
You're
sir.
not upsetting me.
I'm not a
You're
lawyer.
wasting my time,
Okay.
but you're not upsetting.
Okay, are you aware you will need to refill the holes and repair the siding damage by that occurred when you installed the camera? When you leave, you'll have to do those repairs, fill in those holes from the camera?
Under the terms of the lease, she has to restore the premises back to a reasonable condition as she got it. I think everybody knows that. Do you understand that, Ms. Lemon?
Yes.
Thank you.
Thank you,
Next
sir.
question.
I think I've already asked about smoking. Okay, and you don't, okay, are you prohibit smoking? She knows that. Okay, yard and maintenance. Are you responsible for mowing, trimming hedges, watering plants, and snow removal under the lease? Line item number 24.
Yes.
Okay, have the hedges been trimmed as required by HOA rules? Do you plan on getting them trimmed so that I don't get a fine from HOA?
Have you gotten a fine?
Not yet, but they've said.
Okay.
Okay. Vehicles. Did you have 2 inoperative and or unregistered vehicles on the property?
The vehicles were,
Okay. Were two of those vehicles towed away? Okay. Did those vehicles cause oil stains in the driveway? Okay. Do you plan on hiring a professional contractor to remove these oil stains?
The oil stains are really there.
Subletting and insurance. Are you currently living at the home by yourself? You already answered that.
Yes, that's
Okay. Have you sublet any part of the home to another person? Are you aware that subletting the home is prohibited without written consent? Do you currently maintain renter's insurance as required by the lease?
Yes.
Okay. On May 5th, 2025, rental application, you listed your current address as the Arlington Drive, correct? Okay. At the time, you were actually residing at 5 Maplehurst Drive, where eviction proceedings were pending, correct? You were residing somewhere else that you didn't put on the application as your current address.
That's for prior address.
No,
Prior
it said current.
with Maplehurst have to do with Shady Court.
Because you were being evicted, I based my decision to rent to you based on,
Anywhere that Sorry.
Maplehurst, they started eviction proceedings in January of 25. I was not made aware of that when I rented my home to you. Did you disclose that the pending eviction of your true address to me before moving in? Did you disclose that address to me before moving?
Was she required to?
Yes, the application said, where's your current residence? So I could follow up with the landlord of that residence.
That was not your question.
You
asked her whether or not she disclosed an eviction.
Yeah, did
On
you?
the application, does it indicate, have you been evicted?
Yes, there's a section in there, any prior evictions on the application.
All right. At the point in time she applies, has she been evicted?
There were eviction proceedings.
Is that what the question asks?
No, it says, have you been evicted?
Thank you.
Oh, sir?
So that case had not concluded, is that correct?
That's correct.
Okay, then if you're saying that she misled you, your question is bad.
Well, but
as it has been all this morning.
Okay, but she didn't disclose where her
You want to
address
argue
was.
with me?
No, honey, I'm sorry.
She doesn't have to answer that question, or actually she answered the question.
Okay. Are you aware your lease states that breach of the lease gives the landlord the right to repossession? Line item number 32. Are you willing to remedy the lease violations or return the property to me? Okay. Do you understand line item number 36 on the lease? Only written agreements signed by both parties are enforceable under the lease. So verbal doesn't mean anything. It's only written.
You answered that. Okay.
Okay. This is questions with regard to the lease application. Miss Lyman, are you aware that the phone number you listed on the lease application, 734-460, is that correct?
I listed that number back in 2023.
No, on the application you just gave me, in 2025, you have that number on the application.
I used the same registry from 2023.
Okay. Are you aware that according to reverse lookup, that number is this number is registered to you, but I've never received a response when texting or calling you on this number?
So, okay. If she says yes to that, what's that mean to me?
Okay. Okay. Scratch that one. Okay. Isn't it true that the only way I have been able to communicate with you is through your mother, Joanna Lyman, at 734-46?
No, you don't know. And that's not number.
Okay. Please confirm, do you regularly monitor or respond to your phone you listed on your application? Well, I guess that would be no, because you...
Well, are you going to answer it, or are you going to let her answer?
Okay, sir. Sorry.
It's fine. You just send a lot of messages.
Okay, so the number 734-465-8335 is the best number.
Yes.
Okay. Okay. On your application, you listed your current address as Arlington Drive, correct? Current address, okay. Isn't it true that at the time you completed your application, you were not living at 9 Arlington Drive, but at 65 Maplehurst? But you were living at Maplehurst. Okay. Isn't it also true that you were being evicted from Maplehurst property owned by Miss Gloria Vanderwell, your former landlord? She's the owner of the property. Greg is her husband. Okay. Yeah, that was the person that was at the prior trial. Yeah. Okay. On your application, you stated that you were renting a room from your parents, Desmond Jones, at $500 a month, correct? Well, it's on the application. It says Desmond Jones, and you told me you were living with your parents.
I said living with the family.
Okay. But on the application, it says you were living at 9 Arlington and paying $500 a month to your family. That's what the application says.
Yes.
Okay. You also wrote that the reason you wanted to rent my home was to have a place of my own, correct? Okay. In reality, weren't you leasing your own home at 65 Maplehurst at the time and facing eviction for non-payment of rent and property damage?
What does Maplehurst have to do with
the question is because you falsified the application, so you committed.
That's a conclusion.
If she said her current address was 99.
It's a conclusion. Get to your next question.
Okay. Do you admit that the address you provided on your application was false? Do you understand that providing false information on rental application is considered fraud?
Well, don't answer that. That's a legal conclusion you're asking.
I've been doing my Google searches, sir, and this is what I come up.
Well, then bring Google.
Is she typing all this, sir? Was I given?
You know what?
I'm just asking.
You know what? You know what? I'll tell you what. I'm taking a break. You get your questions in order, and you understand how to address this. Am I clear?
Yes, sir.
Have a seat. You may step down. Court is.
All right. CNA District Court, County of Washington, State of Michigan. Judge Jason.
You may be seated. Ms. Lyman, why don't you come on back up? You may continue your questioning.
Thank you, sir. Do you admit that the address you provided on your application was false as your current residence? Do you understand that providing false information on rental application is considered fraud?
You already asked that question.
Oh, I'm sorry, sir. I
Strike it.
forgot where I was. Was I given truthful information to conduct my due diligence as a landlord, or did I base my decision to rent you on falsified information?
She's not going to be able to answer that. That's in your mind.
Okay. Sorry, sir. Your driver's license issued in 24 showed 90 Arlington Drive as your address, correct?
Yeah.
You were actually living at 9 Arlington Drive when your driver's license was issued, or were you living at 75 Maplehurst?
What does Maplehurst have to do?
Do you acknowledge that listing 9 Arlington as your address misled me about your true living situation at the time? Do you understand that I relied on information you provided in your application when deciding to rent to you? Are you aware that had I known about your prior rental history of fraud, non-payment of rent, and property damage at Maplehurst, I would not have rented my home to you?
She can't answer that. That's you.
Okay. Would you agree that my decision to rent to you was based on information you provided that was not?
She can't answer that. That's you.
Okay.
As to the form of your question.
Ms. Lyman, are you aware that Mr. Diop Dimba has owned and lived in Arlington Drive, Superior Township since December 21? You and your family rented the property from the previous owner prior to December 21, correct?
Rented what property?
Arlington Drive?
Go ahead, you can answer it for what it's worth.
No, you didn't rent it? After Mr. Demba purchased it, you did not live there, true? Okay. Your driver's license lists 90 Arlington Drive, Superior Township as your address, correct?
You already asked and answered, don't answer.
That driver's license was issued July 16th, 2024, while you were living at 5 Maplehurst Drive in Ypsilanti Township, correct?
Don't answer that. Asked and answered.
Did you have permission from Mr. Demba to use Arlington Drive on your driver's license or rental application?
Keep asking about him. I don't know who that is.
Okay. Did you use Arlington Drive to mislead me, the landlord, into renting my property to you?
You asked for a previous address. I gave you a previous address. I don't know.
I asked for a current address on the application, not a previous.
Any more questions about Maplehurst or 99?
Did you knowingly provide false information to gain advantage in renting my home? Okay. Are you aware that using someone else's address without permission is considered fraud under Michigan law?
No, she can't answer that. You're asking for a legal conclusion.
Did you understand that this could lead to criminal or civil penalties?
She can't answer that.
Do you admit your use of Arlington Drive was unauthorized? Okay. So, Ms. Lyman, even though you were living at 65 Maplehurst in Ypsilanti Township, your driver's license issued July 16, 24, and your rental application listed 9090 Arlington Drive, Superior Township, without permission to mislead me into renting my home, correct? Ms. Lyman, can you explain why the following damages are present after you took occupancy? Broken master bedroom blinds, oil stains in driveway, broken rear screen door. We already know about changed front door locks and mounted exterior camera, but what about the broken master bedroom blinds, oil stains in the driveway, and broken rear screen door?
The rear screen is on the checklist. So, oil stains in the driveway.
Okay, so you're going to replace the blinds eventually, or? Okay, thank you. Are you aware that under paragraph 18 of your lease agreement, you were responsible for these repairs? Okay, Ms. Lyman, your tenancy began on May 5th, 2025, correct? Are you aware that the property had a valid certificate of occupancy and issued May 2025 before you moved in? Do you understand that a certificate of compliance means the property passed all required inspections and met township standards at that time? Are you aware that of the email from Mr. Frank Daniels, which I forwarded to you, Ypsilanti Township Housing Inspector, stating that the torn screen and torn insulation now present?
Ypsilanti Township?
Pittsfield, I'm sorry, sir, Pittsfield Township. Torn screen and torn insulation would not have passed inspection May 2025. So based on the inspector's statements, those items were not present at the time of his certification, correct? So those damages occurred after you moved in.
The screen door.
The screen door was not on what checklist? The screen door was not, that screen door was not like that. That Mr. Daniels.
Is that a question?
Yeah, the question was, damages occurred after you moved in. Because Mr. Daniels states that the screen door in that condition would not have passed inspection.
What's the question?
Proof of condition that we got.
What's the question?
The question is,
You keep making statements and not.
therefore, the damage occurred after you moved in, correct? Because Mr. Daniels inspected the property and it passed. Then she moved in and he said it would not pass for the screen door.
So what's the question?
Just her acknowledging that she'll repair it in due time.
She already said that she
Okay.
was gonna do that.
'Cause we
I
won't-
mean, and if she
the-
doesn't, that's part of the reason you have a security deposit.
I know, but the problem is when we get the inspection next year, it won't pass with these items.
Okay, and then I don't know how you see into the future that way.
Okay, I'm just trying to cover all my bases, sir. Sorry.
I just want to say that I never said that I repaired the screen door because it was on the checklist.
The screen door was
I
not on the
heard
check.
you.
So you're not gonna repair the screen?
I'm off the screen door. If she says it's on the checklist and you're saying it's not on the checklist and there's damage to that, that's gonna have to be dealt with at some other point. It's not to be dealt with here. She's answered the question about the screen door. Go on.
Okay. You signed a lease that includes section 18, which states that tenant is responsible for damages and repairs caused by tenant during your tenancy, correct?
Asked and answered.
Okay. Are you aware that the torn insulation violates property maintenance code section 102.2? Are you aware that the torn screen violates property maintenance code section 304.14? Do you understand that the property cannot pass inspection next year, May 26, unless these repairs are made?
It's irrelevant. Irrelevant. Next question.
Okay. Do you want to maintain your tenancy at this property?
Yes.
Okay. Are you aware that to maintain tenancy, the property must be recertified May 26 and these repairs are required to pass?
Go ahead, answer that if you can. It's not gonna matter to me.
Okay. So Ms. Lyman, to summarize, the property passed inspection and received a certificate of compliance May 25. You moved in on May 5th, 25, and the torn screen insulation would not have passed inspection. They occurred after you moved in. They violate township codes, and under section 18 of your lease, you are
Is
responsible.
there a question?
Okay, Ms. Lyman. Okay, accountability and lease compliance. Ms. Lyman, do you see that as a tenant, you are responsible for ensuring that all occupants, including guests or family members, comply with lease terms and local laws? Do you see that having unlisted occupants and unsupervised children could put the property of the residents in your tenancy at risk?
How?
Unsupervised children?
Yes.
They were running in the street, sir, and the neighbors complained that they almost hit one.
Then how does that put her tenancy at risk?
Oh, I thought it,
At least you have children? Okay, so hold on. So I don't even understand where that question might even go, given the greatest benefit to the question.
there was a police report that kids were running around unsupervised and CPS got involved.
Okay,
And I provided that to the court.
and so what does it matter if they're not her kids?
Okay, I'm not a lawyer. I'm trying my best, sir.
I can see that you're not a lawyer.
Forgive me.
I gotta ask you the
Okay.
question. I don't know how
Okay.
you're attempting to try to hold her responsible for kids that aren't hers, as you haven't even established her kids that are a guest of hers.
Okay, okay. Appreciate that, sir. Okay, Ms. Lyman, do you, I sent you a copy of the HOA vehicle policy for the neighborhood. Are you aware that the policy states that unregistered or inoperative vehicles are not permitted on the property?
When you were last at the property, did you see?
No, I'm just I'm just,
Are there vehicles on the property?
no, this is,
Then why
okay,
are
Okay.
we dealing with this?
okay. Okay. And you said it's hearsay about Maplehurst, so this next exhibit was all about Maplehurst. So you're saying that that's hearsay?
Ma'am, I don't even know what you're talking about.
Her prior residence, that was this next section. The damages to her prior residence. And
The
that's,
damages to a prior resident, I don't know why that would be relevant to me. And I don't also understand that, I don't even understand how you're getting that in.
well, I just thought showing a history of destruction is relevant to my house and me being concerned. It shows why I'm concerned about my property. I'm not just concerned for, for just to be concerned. I have a reason to be concerned about my property. That's all. I'm just, this is my $570,000 baby. I care about my home.
Anything else?
Oh, so section 6 is off there. So that's it for questions. I wanted to go over I had something for the court, but I'm done with asking questions of Ms. Lyman.
All right. Ms. Lyman, you'll have an opportunity to testify. You may step down. Any other witnesses for the plaintiff?
No, sir.
All right, here's what I'm gonna do. Ms. Lyman, prior to your opening your case, should you decide to give one, court's gonna stand in recess and it will go ahead, you can go.
Do I sit down, sir?
Pardon?
Do I sit down, sir?
You can sit down if you want.
Okay, well, you're the boss.
I know. You ought to remember that.
I do remember. I was gonna wear a hat. I love Judge Simpson.
Here's what I'm gonna do. I'm gonna break for lunch. It's a little bit early, but I thought we might get somewhere this morning. I'm gonna break for lunch. We'll reconvene at 1 o'clock. And then if there are no other witnesses for the plaintiff, then we'll go to defense's case at that point in time. All right? 1 o'clock.
Thank you, Judge.
Not 1:30. 1 o'clock. Okay? Thank you. Court stands in.
You're kidding me.
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Jay is an absolute joke. He's an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green? We're going to start bringing people in first. He's going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, so
I'm
let this feeling
sitting up here. I'm the one that needs a drink.